Presentation by Ms. Bordeleau on complaint.
Yes, so in response to, I think there was a resolution made in the last board meeting, Ms. Bordeleau and Superintendent Mumby are going to talk about the professional standards and the conduct investigations, and they've got a PowerPoint to take us through. Thank you. Good morning, Lynda. Good morning, Gail. Welcome.
This ought to be good.
Good morning. Just have to get the presentation up. Just as we're getting some technical support, at the last meeting there were a few questions on informal discipline, informal resolutions, and the discipline process in general. And it was at that time that we proposed to come back with a presentation, hopefully one that would generate some questions and maybe leave you with the answers that you need, or if not, some further avenues for discussion. So we prepared an overview presentation of discipline, of the discipline process involving sworn members of our organization. Okay. All right, so we're going to advance slides. Okay, so just going back to the main presentation slide, the overview slide. So we'll just walk through the nature. We'll walk through the nature of the police discipline process. This is not going to be a comedy show. We'll talk about the two types of complaints under the Police Services Act: chief's complaints and public complaints, because there's differences in relation to those. And we'll talk about the directives that we have in relation to those two categories. We'll speak about informal discipline and informal discipline. What kinds of conduct falls within each category. We'll talk about the appeal process. We'll give you some statistics, and then talk about the role of the OIPRD and OCPC. So that's the nature, that's the overview of the presentation. So it's important to start with an understanding of the nature of the police discipline process, because it is unique. It's different in nature than what you would be used to in the municipality. The police sector is unique in that we have to abide by the strict provisions of the Police Services Act before we can impose either informal or formal discipline in relation to a police officer. And the reason for that is because of the statutory office that police officers hold and the powers that come with that. So we do have what we call really a complete code for discipline, which is Part 5 of the Police Services Act. So under the Act, the members of the public can make complaints, and we'll talk about the public complaint process. But a chief of police is also considered to be a complainant under the Act. So we have a chief's complaint process, which results in internal complaints going forward in relation to the conduct of our officers. And flowing from that, you have either formal discipline for matters that are of a serious nature, and informal that really flows from those matters that can be seen as an administrative matter. We'll talk about the categories of that. And it really is guided what lane we go down. We're guided by the seriousness, by the nature of the misconduct. So just the last point on that slide that I just wanted to emphasize is that the legislation does not define what constitutes serious misconduct. It doesn't define what falls under informal discipline. And in fact, it's important to note when the Act was changed in 2009, the province expanded the ability for a chief of police to impose informal discipline. So as a result of that 2009 amendment, where we can impose a lot different types of penalties, you see in the province informal discipline numbers on the rise. And we'll talk about our own stats in the presentation. So then you can jump in at any time, Superintendent. Okay. So internal chief's complaints, they're referenced in section 76 of the Act. So this is where the chief of police can determine an issue to be a misconduct matter. So a chief can look at an issue, and sometimes it takes an administrative review process, which means the chief will look at some facts in and around an officer's conduct and decide, okay, does that meet the threshold of a complaint? So am I, as a chief of police, going to exercise my discretion under section 76 to initiate a formal complaint against one of my officers? So that's the chief's power. So if the chief decides to do that, the chief has to comply with a very formal process. There has to be an investigation undertaken, and that's by internal affairs within the Professional Standards Bureau. And there has to be an investigation report done at the end of the day that the chief reviews, a written report. So then it's the chief who makes the decision as to whether the misconduct is substantiated. And really the test for that is there a reasonable basis? It's a reasonable ground standard to substantiate misconduct. So if it's not if there's no evidence of misconduct, it's unsubstantiated. If it is substantiated, that's when the chief has to decide, okay, what stream are we going to go down? Is it conduct that is serious in nature that requires us going to a hearing? Or is it of an informal nature? Okay, so what are examples of serious misconduct that we deal with? So excessive force, I think it's fair to say, Chief, that if there are allegations of excessive force, those go along the formal route. And what is meant by the formal route is a hearing must be held. We can't discipline an officer on a formal matter or a serious matter without holding a public hearing. Matters of criminality. So if an officer is charged with a criminal offense, whether it's on duty or off duty, that's a serious matter that goes through a formal hearing process. In the province, chiefs have, well, this chief has determined that privacy violations, secret violations, are serious misconduct. So what we mean by that is if an officer accesses our operational tools, which is the Canadian Police Information Center, and that, or our internal reports, if they access those for a personal reason, for a non-operational reason, that really is a privacy violation, an alleged privacy violation of an individual. We consider those to be serious, and we will go down the serious, the formal route for that. And the basis for that, just so that the board can appreciate it, is that we're aware of, the civil tort of invasion of privacy now in Ontario, where a member of the public could sue the board for any improper breaches of an individual's privacy. So we really have to take these matters seriously for deterrence reasons. Okay. Harassment based on a prohibited ground of discrimination is also seen as a serious matter, whether it's racial or sexual harassment, and those will go down the formal route. So again, if it's formal, we have to hold a public hearing. Okay, so that was formal. What constitutes informal?
Sure. Informal discipline, again, is of a lesser nature, and I really think our officers are held to a very high degree. So when you see an informal number, that includes incivility. It includes red light camera violations. So if an officer is on his, on their way to a call, and they go through a red light without doing the prescribed things within the Highway Traffic Act, they can be given informal discipline for that. Motor vehicle accidents, failing to submit occurrences, failing to complete proper notes, failing to attend scheduled traffic court, failing to attend training, loss of equipment. There's a whole host of reasons that fall under informal discipline. And those could be some of the things listed, and quite frankly, there's a whole host of others that would be considered of a lesser degree.
Okay. So we have to be mindful too, again, under the statutory code, an officer has the right to refuse informal discipline. So if they don't agree with us and they feel that really they acted appropriately, it requires us then to hold a public hearing. So again, it's very different from, you know, the municipal sector where we can impose even informal discipline without there being sort of a procedural fairness component to that. Okay. So then just to alert you to...
Sorry, Lynda, if you could just go back on that.
Oh,
Just-
okay.
Maybe you could just explain to the board that, give an example, the fact is, so if we wanted to dock somebody for an informal discipline and they refuse to accept that penalty.
Right.
Just explain the process for that.
Okay, so if an officer feels, you know, that they have perhaps a reasonable explanation for not filing a report or well, we have no going on that, so I won't speak about that. So if they feel that they have a lawful excuse for something, where we're saying you were in neglect of your duties, then they can say, no, we're not accepting that. So management could either walk away from that discipline or say, okay, no, we've got our rationale too, so we're required under the Act then to hold a public hearing. And that puts us to the test of meeting the requirement of proving misconduct on clear and convincing evidence. Then the officer has a chance to explain why they didn't do something that we're saying they should have. But that's sort of, and it is onerous, right? But it's there because of the professional reputation that flows with the statutory office, right? So that's why officers have all of these procedural safeguards, is really the high reputational interests that we need to get the job done. Okay, so then just to flow from the chief's complaints and public complaints, we've just alerted you to the two directives. And the Code of Conduct Directive is really an important one for us because it really does set out, and I think it's probably helpful at some point for you to review it. Peel has a specific code that's in addition to what's set out in the regulation to the Police Services Act, and it's been around longer than what I've been working with you for 10 years, and it was in existence long before then. So there are provisions within that code in terms of ethics and integrity that we can point to when we're looking at these conduct issues. So it's really a reminder to officers that, you know, in addition to the Police Services Act, we have our own expectations and requirements. So we're pretty specific on that. We always include the Code of Conduct in our investigations because it goes back to the basics of the principles that we strive to meet, I guess. When it comes to informal discipline, there is an informal discipline review board, and that's been established to create some consistency in the organization. As you can appreciate, 2,000 officers, there are minor issues that happen from time to time where divisional commanders are dealing with issues. Officers deserve to be treated in a fair and consistent way. Do you want to speak about that, Committee?
No, there is a process, and the process is, if it is established that it's going to go down an informal discipline process, then it would go to the Informal Discipline Review Committee. So chaired by Deputy Chief McCord, and everybody, all of the executive would be a part of that to, I guess, review each individual incident and make sure there is consistency flowing from them. So, and you know, everything is documented, and the reasons for that is for consistency.
So the board is comprised of the deputies, but the inspector in charge of professional standards is there really to hold the consistency piece, to advise of, you know, what has happened for similar types of conduct. And the penalties include forfeiture of time, reprimand, or directed counseling or training, matters such as that. So now we're going to move into some statistics, so you get a sort of a snapshot of what we're dealing with now and what we've dealt with in the past, I guess, to a certain extent. Okay, so formal discipline. What is going on today in respect to hearings involving Peel Regional Police officers? So we do have 21 ongoing discipline hearings. Okay. 7 involve suspended officers, and that's where we are saying that they're no longer, based on the allegations against them, they are no longer suitable to be a police officer in Peel. So out of the 7, I just wanted to note 2 involve the same officer. So it's not 7 officers, it's 6. We have 3 cases that are we're holding in abeyance because the officer one officer's on medical leave, and then we have the Crown directing us to stay our internal process because there's an ongoing criminal process that we have to wait for. So of those 21 cases, 13 involve off-duty conduct. So that's conduct that officers are engaging in their private lives. And that's the difference too in policing, right? To a greater extent than any other sector, where under the Police Services Act, police officers can be subject to discipline if their behavior meets the statutory threshold. That's section 80 sub 2 of the Act. So if an officer's off-duty conduct, either one, impacts their occupational requirements as an officer, or two, impacts the reputation of the police service. So because of their statutory office, off-duty conduct can attract discipline. 8 of the 21 involve criminal charges. Okay, so those are the stats on the ongoing hearings that we're managing. Informal discipline statistics. So this is the information we've given to the media recently. So we've had 893 incidents of informal discipline over a 6-year period. So actually that's probably more of an updated number because we've included a few months in 2016.
We
right?
included the last one from 2016.
Right.
I think it was originally reported 876.
Okay.
informal discipline.
So what constitutes those informal discipline entries? So 35% of them, or 331 incidents, involve motor vehicle related matters. Did you want to elaborate on that?
So if an officer is in the performance of their duties involved in a motor vehicle collision and deemed to be at fault, they would be internally disciplined through the informal discipline review committee for that. So that's what that would be.
And that could involve forfeiture of time and or training issues. And then 27%, or 245, involve red light infractions.
So again, under the Highway Traffic Act, there's certain obligations an officer has to perform when going through a red light. You must stop, look up, make sure everything's safe, activate your lights, siren, everything else. If it's deemed that they have gone through a red light they don't follow that entire process, they again will be informally disciplined through this process, and that's where that would flow from again.
Okay. And then 38% include a variety of other misconduct. So that could be the administrative role, duty notes, not putting in, reports or
Loss of equipment.
Loss of equipment, not getting disclosure in on time to the Crown, things like that. Okay. Okay, so then I guess we'll take questions at the end, Chair, or is that?
You can certainly ask questions if they're interested, but it looks
Okay.
like this
We'll
is
keep
such
rolling.
a riveting
We'll keep rolling.
presentation.
Yeah, it's riveting.
Asking questions.
You bet. Okay, we're just about finished. Keep rolling. So then we move from the chief's complaints to public complaints, where a member of the public can make a complaint. So really just to say that, again, we've got a statutory reference here, and under this side of the complaint puzzle is the OIPRD overseeing everything essentially. Every step of the way, the OIPRD is sort of directing how we manage our public complaints. So just to keep in mind then, if the OIPRD does indicate that a public complaint is appropriate to be investigated, sometimes they vet them out for public interest reasons, a variety of different reasons, then either the OIPRD can retain them and investigate them with their own investigators, or they allow Peel to undertake the investigations ourselves. And I think it's important to know that it's a really small number. You've got the stats, Dale. Really, the majority of public complaints are investigated by our Public Complaints Bureau, and I think that's a good thing. So there are some that the OIPRD feel they need to retain, but it's probably like a eighth or...
Yeah, it's a very, very small number. I don't have that number on me right now.
Okay.
But it's an extremely small number.
And also the OIPRD can direct another police service to investigate one of our public complaints. And we've never had that happen. in the last 10 years at least. Okay, or last, I should say, since 2009 when the OAPRD came into effect. We have, though, been assigned investigations of other police services. So we've done recently an OPP, a public complaint involving the OPP, and we've investigated that.
I think it's also important to note that even though the OIPRD may tell us to retain the complaint and investigate it, they still review the complaint at the conclusion of it. So they are involved in the process from start to finish.
Okay, all right. Then on this slide, I think we're just trying to emphasize that really the intent behind the public complaint provisions under the Act is really to achieve a resolution. It's really not of the same sort of corrective side of the house that the chief has to make sure her members are dealing with our policies and the conduct appropriately. There's a real different sort of flavor to the public complaint process where they're really looking at sort of a mediated resolution where, to a great extent, it's explaining the police powers to the member of the public when a complaint arises that often results in a resolution. So that you see a specific regulation under the Police Services Act dealing with local complaints. And those are the complaints that we're able to deal with an alternate dispute resolution process. And we're really successful at that. When an officer comes together with the complainant and often explains, well, here's why you got a ticket, you know, for going through that stop sign or what have you. So we have really effective investigators on the public complaint side of the house. But again, the OAPRD is the oversight of all of that and monitors the status of these matters. Okay, all right. And then we have a public complaint directive setting up the process so our officers understand it and that our investigators comply with it, essentially. Okay, so that takes us to an area where we've had some discussion with the board, and the chief recommended that we reference this area in the presentation. The board's aware of a number of criminal court cases that have gone through the system, and as a result, a judge may make negative comments about the conduct or the testimony of our officers. And so what do we do about that? How do we address those? So the Crown's office, and this is probably about 6 or 7, it was at the time of Chief Metcalf's tenure, was when we really started seeing the Crown trying to address, by way of a protocol, these types of issues with the judiciary. So there is a process where the Crown is supposed to notify the chief of any concerns that the Crowns in the field have with respect to either the conduct of our officers on a case or the comments of a judge. But it's interesting that really the majority of these issues have come out of media articles, not from the Crown's protocol. So at the end of the day, it's like a reverse process where we're trying to get on top of what is a media article and say, okay, like let's look into this, and we notify the Crown. You know, let's get the transcripts. We put this to a administrative review investigative process under which the Crown is a key part of that. I mean, it's not really supposed to work that way. We're supposed to get, you know, a notification of these issues from the Crown. But at the end of the day, we sort of understand why it's moving that way, because the Crown I don't think we've had really any matters where the Crown has said, we have serious concerns, or we think your officer has committed perjury. So that's why we're not getting them through the Crown. So as a result, we still have an obligation to take seriously any negative judicial comment about the actions of our officers, and the chief does that. So that is the administrative review process. Sometimes that process will also have the additional chief's complaint process added on to that, where we have concerns about the actions of the officers. So we have an obligation in that setting to notify the officer, right? Because at the end of the day, we always have to remember, we can't correct behavior, we can't impose discipline unless we've completed the proper process at the beginning. So we're mindful of that. So we will comb through the transcripts. We will undertake interviews of witnesses. We will speak to whether it's the public prosecution's office. A lot of these issues come out of drug charges. it seems, with the Public Prosecution's Office or the Appeal Crown Attorney. And we'll really be guided by the Crown in our assessment of the officer's actions. Okay. So we're not the only ones looking at the media reports. The Ontario Civilian Police Commission reviews the media clippings as well, and what we found probably in the last couple of years is that OCPC has looked at their authority under Section 78 of the Act. That's where they can oversee how the chief imposes chief's complaints matters in informal discipline, in internal discipline rather, and ask the chief, okay, what have you done about this? We've noted this article, what have you done? So as a result of those, we have actually provided our investigative reports to the commission, and so that they can see, here's the investigation at the end of the day, you know, whether training has been imposed or the matter's been unsubstantiated. We've been very forthright with the commission on those, and our findings have been upheld. We haven't had any directed hearings, because that's what the commission could do as a result. They could direct us to run a process against an officer. So no, we have not had any formal discipline charges in relation to these judicial comments, and that's the nature of our investigative process. But we have had officers sort of given additional training, sort of an informal type of discipline as a result of these matters. So more training, and really the issue from our perspective has been really bad note-taking and not being prepared going to court.
But flowing through this, or from this, there is some benefit, if you will, that when we put this through an administrative review and we have found deficiencies, whether it is in note-taking or testimony, in those cases, we've actually partnered with the Appeal Crown Attorney's Office. They are now working with our training bureau, so they will come in and they will do mock trials and put people through things. They will have an event. The event will take place and they will reattend in 3 months to see how the officer's done with his notes and have a trial to see how that delivery is done. So anything like that, we try to take the negative and find ways that we can then turn that into something that we can actually benefit from. And not just from that one or two cases, but that through the training bureau so that all officers involved are subjected to that to help them.
So just to close off this area, and I know you might have some questions, we realize that any of these judicial comments impact the reputation of this police service. And when that happens, it impacts every frontline officer and everybody who has to go out and try to do their statutory duties. And that's tough when you have, the negative comments in the press. So we take that seriously, and we know we have oversight by the Ontario Civilian Police Commission, and we also appreciate that the board is mindful of these essentially attacks on our reputation. So the last two slides is really just sort of in terms of discipline, the role of the board. One of the biggest areas is really your role in the extension process, where if our investigations go beyond 6 months, you have the authority to determine whether our delay has been reasonable and whether a notice of hearing should be held. Then the last slide is the Ontario Civilian Police Commission. So just to note the Section 78 authority, we wanted to set that out there because we've referenced it under the judicial comments. And then 87 is the fact that OCPC oversees the appeal of officers on hearing officer decisions. And then Section 25 is the OCPC investigative authority in relation to board members, officers, chiefs, deputies, or how a police service is administered. So that's sort of a quick overview of the discipline process, and maybe that will provide some information that will lead to some questions for you.
Mr. Williams?
Is it true an officer could receive an informal discipline for being late for work?
Yes.
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 And that's a radical change from the rest of the world. I mean, people are late for work a lot, but if an officer's late for a platoon shift, he could be informally disciplined.
Well, it depends on how often it happens. If it maybe happens once, I'm sure a supervisor would give some leeway, but you have to remember that it impacts the complement of the platoon or the bureau. So there's a serious implications for somebody not showing up on time.
I just think the public should be aware how strict the discipline is in the
Right.
police force.
Right.
Ms. Nicholson?
Thank you for that very informative information. In fact, I've learned a lot from this. One question I do have, formal with public hearing. Please help us to understand what is the public hearing? Like, it's internal?
Right, so the chief's required to hold a hearing, and we have to appoint a hearing officer, and that has to be either a member of the organization of the rank of inspector or higher, or it could be a retired judge, or it could be a retired member of the rank of inspector or higher. So that's the adjudicator. Then there's a prosecutor, so that can either be a lawyer like myself or somebody, we use inspectors as co-prosecutors. We have to record the hearing, so it's very formal in nature under the Statutory Powers and Procedures Act. We're holding them now at the new facility on the new building in Mississauga, on Mississauga Road. So it's public in the sense that we, on our website, have notification of the hearing or the first appearance, and the media can attend, members of the public can attend if they so wish. A hearing can be closed under certain restricted criteria if there is, that's under the Statutory Powers and Procedures Act. If it's closed if there is informant information or any issues around privileged information, if it impacts a third party in a sense that it could be, you know, personally embarrassing. We've had cases where there's been photos or videos of somebody, a member of the public, that has related to conduct. So we'll close the hearing to minimize the impact on a third party in the process. It's very restricted when we can close the hearing. Otherwise, it's a public hearing, we call evidence, and we have an obligation to prove misconduct on a clear and convincing basis. So that's essentially it.
Thank you.
Thank you. Madam
Sorry,
Deputy?
just on that as well, it's also, maybe you can speak to the how long it stays on their personnel record, what's
Oh,
formal
right.
versus informal?
So if misconduct is proven on clear and convincing evidence, it stays on an officer's employment record for a 5-year time frame. Informal stays for 2 years, but 2 years clear. So if another informal discipline occurs within the 2-year time frame, then the old one continues. So informal discipline retention is spoken to under the Police Services Act. Formal discipline retention has been dealt with in our collective agreement. Okay.
Madam Jeffrey?
I would agree with you on this. It's been a very interesting educational tool for me. And I would say that it's been a learning curve for the last year to understand how the process worked. And I think that there are a lot of checks and balances. And certainly I don't envy the chief's role in determining what constitutes what would trigger the discretion that she has. That's challenging. I guess the only thing I would say is when I read a lot of these reports, the informal resolution piece of it for the public, can you speak at all to that? Is that isn't as clear cut for the public?
I can certainly try. So the oversight, the OIPRD, their entire focus is obviously to ensure that we are performing our duties to the public in a manner consistent with how we should be. The oversight they provide, though, is focused on mediation. It really puts an emphasis on trying to get two parties into a room to have some type of consensus. That isn't always accomplished. There are a lot of times, or sometimes, where two parties in a room just can't agree, and that may move things to either a formal or informal investigation. But the initial part is to get people together to say, okay, what are the two sides of the story and how can things come of this? And that's really what an informal resolution is, that two parties will meet. So, the police officer and the person that has initiated the complaint, they review and hear each other's stories and are satisfied with either, it could be a resolution that they both agree to, it could be an apology comes from that, anything like that. That is an informal resolution.
But sometimes we can't even do that. The OAPRD will say, okay, we see this as a different type of complaint, and we see sort of a discipline component. They'll direct us to deal with it as an informal discipline matter. So then you'll see the attraction of the forfeitures, forfeiture of time and things like that, where if the officer doesn't agree, we have to go to a hearing. So, so the OAPRD is really sort of the entity that is directing us in that regard. So.
And I understand where you're coming from. I guess from a public confidence perspective, and our role as civilian oversight, when I see informal resolution, a lot of times that could be a good thing. But I guess from my perspective, I'd almost like a little more detail as to what that informal resolution was, that there was direction given, that training would happen, or an apology. Like, I just feel like there's more detail that needs to be part of that so that people have confidence. Because otherwise, it kind of just shuts down the conversation that there's a lesson learned from that complaint. And there needs to be lessons learned from all. I mean, it's hard for the public to make a complaint. Right. It's a challenging process, I'm sure, for the officer as well. So I guess for me, I would prefer more information. And I get the other thing that I would think that we, from a communications perspective, we need to do a much better job in explaining this process to the public. And I think that there is an opportunity even for the chief to be writing editorials that explain to the public what your discretion is, what guides your work, what legislation guides it, and the high threshold that we expect all of our officers to keep. And if I don't know it and I'm on the police services board, there's a huge gap and a vacuum in how we explain how you can resolve these issues, how you are encouraged to come forward if you believe there's wrongdoing, and that we will provide transparency in how we deal with it. So just for something that the chief might want to think about, because I think that there's a story to be told, there's a lot of checks and balances, but we want the public to have confidence in how these things are resolved. So, but this is very helpful, and I appreciate that you did this tonight.
And one thing that you've reminded me of is that we are posting the decisions now for a 3-month period from the date of the decision of the hearing officer on our website. So that's providing the public with more of a snapshot of what's happening. And just in terms of our next steps, I just want to make sure I'm clear on the additional information. So you're not talking about the informal discipline, the 893, you're talking more of the local resolutions and how we do that? Okay, because we can provide you with statistics and more of an analysis on that.
I guess I'm not looking for the statistic necessarily. I think that we just need, the public wants to know, if I was a person who didn't believe what you were telling me, I'd say that people dropped it because they couldn't get a resolution. And I don't know that that's always the case, I'm pretty sure it isn't. But I want the public to have confidence that we made a best effort, we tried to find a resolution. And sometimes it's a he said, she said. There's no proof to that either side, but we want the public to have confidence that issues are being aired properly, that it's fair, and that they aren't being discouraged from continuing to complain if they think they're right.
Right. And I think that's where the OAPRD and the requirement to post their information at every division, and we have the pamphlets, because that's also the safeguard for the public as well. If they don't feel we're doing it, and I hope they feel we are, they can go to the OAPRDs very easily. So, okay, thanks. That's great, thank you.
Chief, you want to say something?
Yes, I'm just going to say that I appreciate that, because Dale and I have had conversations with regard to the unsubstantiated, and say, okay, so when are they going to be substantiated? So I've actually, we've reached out to the OAPRD, Mr. McNeely, to ask him then to come to the board too, to reassure them, because it's important for the community to know, and you're probably right, we don't advertise this enough, and we're working on improving the transparency of the discipline process so people get it, but we are following up on this, and we have the early intervention system that if one officer, if Officer Smith or Officer X, I should probably say, is, gets 4 complaints in one area, the early intervention system will trigger that, so we'll become aware of that to look at that officer's conduct. But Mr. McNeely is the oversight, he's the civilian oversight. He's reviewing those complaints to make sure, and I say, I would like to meet the board to have Mr. McNeely to come and speak to that, because I think it's important to hear from him. He's the oversight of all police agencies in Ontario, so, and now you see there's no relationship there. He's the oversight for our complaint system.
John?
Chief, do we have a pamphlet or a brochure that can be given to the public that explains this process in a very simplified way?
Yeah, that's from the Office of the Independent Review Director. We post them in every division. There's pamphlets, there's posters on the wall, so we have that as well. And the Office of the Independent Review Director, they do audits, so they'll walk in and check on our division, and then I'll get the letter saying, hey, I didn't see your posters, I didn't see your pamphlets. And I asked the guy at the front desk, the officer at the front desk, and he had no idea how to make a complaint, so they do spot audits as well.
Fred?
Just for the benefit of the board, further to what she said, Mr. McNeely did reach out through his staff to the chair, requested the opportunity to make a presentation. Unfortunately, the April board meeting didn't work, and then we changed the June board meeting. But he's expressed a strong interest to come to the board and further the chief's comments, so we're hoping to have him here at the September board meeting as well, so you can ask questions for everyone.
Mr. Chair, I can get copies of the pamphlets and the event divisions. Okay, I'll have that done.
Let me make a couple of comments before we close. There are over 400,000 interactions between our officers and the public. Last year there were 69 complaints. One thing I would say that in my last 2 months I have noticed, particularly in serious offense cases, our chief has been swift and decisive in dealing with them. That's a very important tool to tell public we are screening when we hire people, but every once in a while somebody will do some misconduct. But I think the message is coming very clear, I've seen, is that it will not be accepted, it's not going to be tolerated. And I'm very pleased that 2 instances of very serious misconduct, she has been right on it very quickly and dealt with it fairly severely. So I applaud that. Second point I would make is, as we announced it, I think the previous meeting, that there is a new complaint and litigation committee because of the public expectations of more knowledge and more understanding of what's going on. And Lynda Jeffrey and is the chair, and Norma, and Madam Nicholson is the second member, and their mandate is to really delve a bit deeper into it. And all of this thing to help people understand the process and how we are dealing with complaints of different nature. So I think this thing will happen more, and this is in response to what we believe the public expects us to do. So we are following up on that. Thank you.